Welcome to the latest episode of Call to the Bar, International Law Over Drinks. I'm your host, Dr. Tamsin Phillipa Paige, Associate Professor at Deakin Law School. Today we are discussing immunities in international law with our guest, Dr. Dimitrios Kourtis, Assistant Professor at Aristotle University in Thessaloniki, and my wonderful co-host, Dr. Imogen Saunders, Associate Professor at ANU Law School. But before we begin, I remind everyone that in these informal conversations, we are, as always, speaking off the cuff and without the benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. But before we get down to business, our traditional first question. Dimi, Imogen, what's your drink?
I guess Imogen should go first. She's the co-host.
I can certainly go host. Well, go first. Thank you for having me, Tamsin. I am drinking a tea. It is past caffeine o'clock for me, really, being 4:30 in the afternoon. So I'm risking it because this is black tea, and we'll see if I'm up all night. I like to live on the wild side every now and then.
Live dangerously.
Exactly.
Okay, so it's really early in the morning here, so I'm not drinking anything, but I plan to celebrate today's, let's say, discussion with a gin and tonic with a Greek twist. I love Mediterranean herby gins with juniper, but also citrus, masticha, and a few more subtle herbal notes that does not immediately identify, but linger rather pleasantly. So I will pair it with a dry tonic and a slice of fresh orange, just to break out some warmer tones. So that's my plan for today's evening drinks.
That sounds deeply excellent, and if I still drank, I'd join you in one, and it makes me want to be recording this outside with a cigar. But unfortunately, I'm in my home office, and I have a prickly pear black tea, which is a blend of black teas from southern regions of India with prickly pear and safflower petals. And it looks lovely. So far, it tastes okay. We'll see how it progresses. So now, Demi, you and I have never met in person, but we have corresponded first via Twitter, rest its digital soul, and then via email, where I've had the pleasure of reading your work on international criminal law and more recently immunities. And we've been corresponding, I'd say, for a number of years now, and it's been really great from my perspective to read your fantastic work. How does this story look from your perspective?
That's how I remember it, to be honest, and I'm very happy to have met you even via Twitter, especially at the time when Twitter, obviously, now it's dead, but back then it functioned as some kind of informal conference room with chaotic notes, but also productive discussions, and it was remarkably good at the time at bringing interesting people together into the same place. So back then, for its faults, the platform did occasionally allow for these rather unexpected and meaningful connections. So from my side, I also remember coming across first your work and then your Twitter reflections on international law. And to be honest, I was struck not only by the substance, but also by the tone and your visage, obviously. There was something very open, very thoughtful, and if I may add, very generous in the way you engage with others, especially early career researchers. And this thing lingered on, stayed with me, and as our exchanges moved into emails, I felt very much the same spirit. An empowering and genuinely supportive approach to a conversation and to exchange of ideas. This is not always a given in academia, especially in quasi-hierarchical relationships between, younger and a little bit more senior academics. So I should perhaps take the opportunity to thank you for that, both in terms of your engagement with my work and more generally for your support, your empowering conversations, and your advice all through the years. It does make a difference, and I'm really happy and grateful to be here.
Fantastic, and I'm a little embarrassed right now, I've got to say, because that's very kind words, and I don't know how to deal with that. So I'm going to, move on to my next question, which is, you've not been on the pod before, and our general tradition for new guests is to ask you, how did you get into international law, and what career path brought you to your present position in, well, academia for you?
Okay, this is a tough question, to be honest. I think the sincerest answer is that my path into international law was not especially linear or planned ahead. It grew slowly out of a combination of experience, curiosity, and if I'm truthful, a certain discomfort with the world as I found it. So I come from an agricultural area. I grew up in central Greece in a working class environment, and this shaped my instinct from very early on. When you are raised close to manual labor, economic precarity, and the risks and uncertainties of agricultural life, you do need anyone to explain. You do not need anyone to explain you that society is not very equal or arranged on equal terms. So before I had any formal language for it, I thought I had already become preoccupied with questions of power, hierarchy, equality and exclusion, and also at the same time, I was raised among people with immense amounts of dignity. This is something I would never want to lose sight of. I think that stayed with me as well, and perhaps it partly explains why I have never been able to look at law simply as a technical black letter game or an elegant architecture of rules. So when I began studying law, I did not have a grand vocational or professional plan. What law initially offered me was something to make sense of the world, something that it was comforting and safe and secure. It gave me structure. It allowed me to name things, classify them, and impose a degree of intelligibility on a world that often felt uneven and opaque. But as I moved further into my legal studies, I also began to feel that doctrine alone could not be enough. I do not mean I became dismissive of legal method or even uninterested in technical arguments, quite the opposite. But the more I studied law, the more I found myself asking what lay behind legal categories. That, I think, is what drew me towards the study of international law. It seemed to me that the field has all these tensions encapsulated and exposed out in the open. International law speaks in the language of equality, sovereignty, civilization, humanity, peace, the rules-based order. It presents itself, at least most of the times, as a universal normative idiom, and yet it operates in a world profoundly marked by hierarchy, double standards, hypocrisy, imperial aspirations and inheritances, force, uneven development, and selective empathy. I found that tension intellectually irresistible, so international law was the place where I could see most clearly both the grandeur of legal aspiration and the stubborn realities that frustrated. My movement towards international criminal law came quite naturally from there. If one is interested in power, aggression, violence, hierarchy, mass atrocity, and human rights, and the ways law translates social suffering into legal categories, international criminal law is difficult to avoid. I became particularly focused on the law against genocide because it seemed to me that it gathered so many of these questions into a single concept. On the one hand, is the most morally charged and symbolically powerful term in international criminal law in particular, and on the other, it is also highly technical, with all the constraints, exclusions, and interpretative anxieties that come with that. So that eventually led to my doctoral work on genocide and the right to exist, which later, let's say, developed into my monograph on the same broader field from the viewpoint of international criminal law. And I have to, let's say, make sense of, if I had to make sense of the path that brought me here, I would say that it has been guided less by career design than by a recurring set of concerns. I kept returning to the same basic questions: how power becomes normalized, how legal order presents itself as neutral, how suffering becomes visible or remains invisible. And that, for better or worse, is what brought me to where I am now. It's a journey that has taken me from an agricultural and semi-peripheral region in Greece to lecture halls, archives, courtrooms, and more footnotes than I care to admit.
That's such a rich story of how you got to be here, and I'm sure it's, going to be encouraging for many of our like more junior listeners to hear that the paths are varied. It's no, not too dissimilar path to how I ended up here, and it's nice to be not the only person in international law who doesn't list Jessup as why they're an international lawyer. So I really appreciate you sharing that. But we should move on to our why we're here, which is beyond an ability to catch up and chat, is to talk about immunities. First of all, what are sovereign or state immunities and why do we have them? Let's kind of unpack this for our listeners.
Okay, so the most straightforward way to begin is by saying that state immunity is the claim that one state is not ordinarily subject to the courts of another state. So if a foreign state is sued before a domestic court, the first question is often not whether the claimant has suffered a genuine tort or wrong or whatever, or even whether the legal argument is otherwise persuasive, but whether the court may exercise jurisdiction over that state at all. And that is where immunity comes in. It operates as a limit on the ordinary authority or jurisdiction of the forum state's courts. It may concern adjudication, that is the very hearing of the case, but may also concern enforcement, which in some respects is even more sensitive because it involves the attachment, seizure, forfeiture, or other constraint measures directed against the property of a foreign state, the sovereign property of a foreign state. The traditional explanation for all of this is the principle of sovereignty and sovereign equality. International law, at least nominally, proceeds on the premise that states are juridically equal. They differ enormously in power, capital, influence, and potential, but formally they are treated as sovereign equals. Once one starts from that premise, there is something structurally awkward about one state's court sitting in judgment of another polity. Jurisdiction is not merely technical competence, it is one of the clearest expressions of sovereign authority. So to adjudicate is to assert the right to speak authoritatively in terms of law and fact, to determine rights, obligations, and compel compliance. So when one state brings another before its courts, what emerges is a tension between two sovereign claims. The forum state, on the one hand, says that this matter falls within my legal order, my domaine réservé, so I may adjudicate it. The foreign state replies that I'm not an ordinary litigant before you, I'm your sovereign equal, and that power cannot simply be exercised against me, as though no special question arose. Immunity, thus, is the legal mechanism through which the tension is managed. For my part, I think that immunity is neither just a principle or a right or a privilege, as international lawyers would normally articulate the concept, because these words do not entirely capture the matter on its own. Both formulations tell us something, but each also conceals something important. So, seen in Hoffeldian terms, jurisdiction is best understood as a legal power of the forum state. It is the legally recognized capacity of the court as an organ of the state to alter the legal position of another party through adjudication or enforcement. I find that formulation useful for several reasons. It helps to explain why immunity is not just a rhetorical gesture of comity or courtesy, nor a polite diplomatic fiction. It is genuinely legal in its structure, and also it helps us see the real issue, which is not simply whether a state has immunity, but how international law allocates legal power between the forum and the defendant state. That also explains why the doctrine has never been entirely stable. In its older and more absolute form, immunity was often treated as flowing almost automatically from the sovereign character of the defendant state. Modern states, however, do many things that do not seem particularly sovereign or public law oriented. They trade, they borrow, they employ people, they acquire property, they litigate commercial cases, they enter a whole range of relationships that do not sit comfortably with a wholly absolute conception of immunity. Once that became impossible to ignore, the law had to evolve, and so the focus shifted from the mere identity of the actor to the nature of the act. The key question increasingly became not simply, is this a state or is this a state entity, but what kind of conduct is this and does immunity still attach to it? The deeper problem, however, did not disappear. The law of immunity remains difficult because it is built upon concepts that are themselves pretty, let's say, unstable and variable and contested. Sovereignty, jurisdiction, equality, public authority, and private conduct. And that is why this area of law so often appears technical on the surface, while in fact encoding some very large and deeply political questions or even ideological questions about the nature of the state and the organization of the international legal order.
I'm going to jump in here. I mean, I think that's such a thorough response, Dimi. Thank you so much. The one thing that I wanted to add about immunities is it's not always a very satisfying area of international law, and what I mean by that, at the very least, it can lead to outcomes that might seem unjust. Unjust to the layperson, but also unjust to international lawyers, perhaps. And in this way, I'm always like to think about the jurisdictional immunities of the state case, which Germany brought before the International Court of Justice against Italy. Now, for those not familiar with that case, it related to claims from Italian victims, well, the families of Italian victims of Nazi war crimes that occurred during World War II. And these claims were being brought before Italian courts against Germany. And so Germany brought a case to the ICJ asserting its sovereign immunity in that case, and so that the Italian domestic courts couldn't hold Germany liable for actions of the war criminals. Now, why this feels, I think, a little unsatisfying is Germany didn't argue that it wasn't responsible for the acts of the Nazis. It didn't argue that the acts didn't occur, and it didn't argue that they weren't war crimes. Germany accepted all of those things, that war crimes had occurred, they had been carried out by the Nazi Party, and that Germany was internationally responsible for them. But what Germany said is, nonetheless, we are entitled to sovereign immunity before domestic courts of another state because these are official acts. And there's something I might just put an asterisk on there to sidebar, because there is a difference here between what's treated as official acts for sovereign immunity and what's treated as official acts, or what's starting to be suggested should not be treated as official acts for personal immunity. But we'll talk about that a bit later in the podcast. Now, the reason why I think this was deeply unsatisfying is because what it effectively did was it left the Italian victims without redress because they couldn't bring their claims in German courts. And the reason for that was that Germany at that point was relying on a payment it had made to Italy back in 1962. It had given them about €1 billion in today's money and said, look, this is the agreed sum for all damages done by the Nazi Party during World War II. And Italy had agreed to it at that point. But what Italy didn't do was allocate any of that money for war crimes. And so you have this class of people in Italy who have not received any compensation. And so they started going to the Italian courts to try and get that compensation. While the court was legally right, the judgment that I really appreciate in this case is the separate opinion of Judge Benuna. I'll just make sure I'm saying his, yes, Benuna. Because what he agreed with the court and he voted in favour, but what he did is he brought out that connection between international responsibility and immunity to a greater degree. And I'll just find the paragraph, sorry. So what he said, and I'm just going to read his quote, he said that while the court does indeed recognise that the granting of jurisdictional immunity to a state does not affect its international responsibility, it fails to draw any concrete conclusions from that fact. Thus, it could have added that a state which flatly rejects any engagement of responsibility on its part loses, by that rejection, the right to claim immunity from jurisdiction. And so he went on to say, when immunity is claimed, it comes with an obligation, namely that the state must assume its international responsibilities by appropriate means. And I consider that, in respect of armed conflict, such means include interstate negotiations, but on condition that such negotiations are conducted on terms capable of covering the entirety of the situation at issue. So his point was that Germany does have immunity, but his argument was they should only have that immunity as long as they are willing to fulfil their responsibility through the appropriate forum, i.e. through their own domestic forum, allowing such claims to be heard, or through negotiating with Italy a sum for compensation which would cover the victims of war crimes as well as the sum that had already been paid. And his argument was, without that, you shouldn't be able to, as a state, claim immunity if you are going to use it to dodge your international responsibility. Now, that is not where the law sits at the moment. At the moment, there is no condition that immunity can only be claimed where a state is meeting its international responsibility. But I think it's where the law should sit, because immunity was never meant to mean, well, I was about to say immunity was not meant to mean impunity. That's not probably strictly true. Maybe historically immunity was meant to mean impunity. But in today's world, I think the doctrine has developed so it, at least we say it shouldn't mean impunity. We say what it means is that claims should be held in the appropriate forum. But if a state is not allowing those claims to be heard, then I think there is a question to ask as to whether a claim of immunity should be upheld or whether a state can effectively void their own immunity by their unwillingness to meet their responsibility in other ways.
Tamsin, if I may just add one
Please,
thought
please do.
to
And I am just going to say,
Imogen's
before we
point.
move on to, after you do that, and before we move on, are either of you happy to talk about the ARA Libertad, or would you like me to do that as the law of the sea nerd?
Yes, that's great. So just a few thoughts. I have been criticizing the ICJ jurisdictional immunities case ever since I was a master's student. I remember that the first time I dared to exercise criticism was around 2013, I believe, during a European Society of International Law Agora forum, and it was pretty iconoclastic at the time. However, from my perspective, and I'm speaking both as an international lawyer, but also as a Greek citizen, because Greek citizens have been affected greatly by the jurisprudence, sorry, of the International Court of Justice. I find that the court's proceduralism was all too comfortable. It insisted that the immunity does not entail impunity, as Imogen highlighted, although immunity historically was a road map or a rule of compass which said that some things should remain beyond the scrutiny of domestic courts, some things should be referred to another forum, or some things are so vital for the state that they are always connected to state sovereignty. So immunity, okay, does not entail impunity nominally, because claims can be pursued in an appropriate manner to another forum at the interstate level. It winked to Germany and Italy to reach some kind of compromise based on negotiations and diplomacy, or generally speaking, pursue other forums consensually. However, both the Greek experience of victims and the Italian experience of victims, to be honest, shows precisely how fragile that reassurance could be. One domestic jurisdiction is closed, that is the Italian domestic jurisdiction, after a lot of various, let's say, developments, because as you know, the Italian government tried to bind domestic courts by adopting a domestic statute, obligating them to respect the res judicata emerging from the judgment of the ICJ. However, the Supreme Constitutional Court of Italy, in the Simoncioni judgment, felt that this is not the case. It used a strictly dualist approach, separating the legal sphere of international law and domestic constitutional law. It used a very, very old safety valve developed by Italian constitutional theory, the theory of contra limiti, which kind of means that if international customary law violates, breaches the core of certain fundamental constitutional provisions, something happens, a security or safety net is activated, and international law, customary international law, cannot be incorporated into the domestic legal order. So basically it found unconstitutional a lot of provisions, including some in the concrete case, in the case at bar, some provisions of the UN Charter, which is really interesting because this happened to pursue justice, substantive justice, material justice. However, it happened in a legally precarious way, which allowed for a lot of good old black letter formal legal criticism to the judgment of the Constitutional Court of Italy. Anyways, my idea here, or my problem here, is that tangible justice cannot find these victims, cannot be brought home to these victims for over 70 years. So either the court was too benevolent in its pronouncement that states would negotiate at some point, or the court basically recognized that immunity still means impunity because state consent, diplomacy, and power politics, because out there is not a legal heaven, it's a political arena between various gladiators and various actors. So this arena might not be so, let's say, justice oriented as the courtroom in The Hague.
Mm.
Yeah.
Yeah,
However, oh, go, Imogen, go.
sorry, I was going to say I completely agree. Tamsin, I'll pass on to you.
I was going to say sometimes immunities does result in that good feeling of the right outcome, and we have the ARA Libertad to thank for that, which for those who are unaware is an it-loss case for prompt release of a ship. It's an Argentinian warship. It's a tall-masted sailing ship that is still technically a warship, and it got arrested in a Ghanaian port at the behest of a New York equity fund over Argentinian sovereign debts. And the Argentinian government went to ITLOS against Ghana, saying you can't arrest this ship. It's a warship. Warships have immunity per UNCLOS. Give us back our ship. And ITLOS said, yes, it's a warship. It's immune. And so therefore, hedge fund bros were foiled by immunities, and that always makes me happy. So, but
No worries.
so moving on to our next question. So how do these sovereign immunities differ from diplomatic and individual immunities? And what's the difference between a personal immunity and a functional immunity? And for you, Imogen, for our Australian politics nerds who do listen to us, would the Governor General have immunity?
Eh, So, if I'm to start, state immunity concerns the state itself. It basically asks whether a foreign state, as a sovereign entity, may be sued before the courts of another state, or whether enforcement or constraint measures may be taken against its property. On the other hand, diplomatic immunity, for example, operates differently. It protects diplomatic agents and missions, and it's governed by fairly specific treaty regimes, most obviously, for example, the Vienna Convention on Diplomatic Relations. So, the next important distinction is between personal immunities and functional immunities, as you pointed out, Tamsin. Personal immunity, or immunity ratione personae, is status-based. It attaches to the office itself and to a very, very limited category of senior officials. Obviously, we have a lot of disagreement about the exact number and identity of these officials. We have both the ICJ and the ILC, crossing swords over whether it is a numerus clausus or we should add more people. But anyways, high-ranking governmental officials can be recognized once seen. While this kind of immunity is really important because it attaches to the office itself, it is also tied to the temporal scope of the office. It lasts only for as long as the person holds that position. While it lasts, it is extremely broad, covering both official and private acts, because the point is to ensure the unimpeded performance of important governmental functions. For example, a governmental immunity, high-ranking governmental immunity or diplomatic immunity falls broadly within this personal category, but however, they do possess different frameworks of reference. Functional immunity or immunity ratione materiae or materie attaches not to the office but to the act. The question here is whether the conduct was carried out in an official capacity and is therefore attributable to the state. If so, the individual may invoke immunity, not because of who they are, but because they acted or their act is treated in law as an act of state, or because they acted in the name of the state. This is why functional immunity can even survive the termination of a person's office. A former minister, military officer, high-ranking like a general, or other state agents may no longer enjoy immunity ratione personae, but may still claim functional immunity ratione materie for acts performed on behalf of the state. So, simply put, ratione personae is basically office-based and temporary, while ratione materiae is act-based and may outlast the office. What is interesting is that personal immunity is broader but also narrower than functional immunity. It is broader because while it lasts, it covers all acts, including even private ones. For example, I don't wish to pay my rent, so I'm kind of protected prima facie based on my status and my office, so immunity might mean impunity at some point again. And
Can I
also it is narrower because it's reserved to a very small class of senior office holders.
I'm just going to jump in there, Dimi, if you don't mind, just to say, living in Canberra, we have the perpetual issue of diplomats and others who don't pay their parking fines
Oh yeah.
and claim immunity.
Was
So,
also a huge issue in New York when I lived there with UN ambassadors with that same problem.
I mean, in Geneva as well. I believe that Switzerland has even issued official demarches to other states about this situation. However, this is highly indicative of how immunity operates in praxis, because in theory we might say a lot of, lofty things about sovereign equality, but at the end of the day it might be not paying reparation for war crimes or not paying a parking ticket. So regarding the Governor General, I don't feel very comfortable to answer, but I would put it cautiously and at a very concrete level. The relevant question would not really be about the domestic prestige of the office, but whether in international law the office holder is treated as falling within the class of persons entitled to personal immunity by virtue of their representative status, because basically the same principle underlies all these types of immunity regimes to do not impede the exercise of sovereign functions on behalf of the state, because we have this corporative logic, this corporation-like logic about the state. This is obviously something that has been given through the evolution of legal relations and legal theory under a structure of capitalism. We think that the state operates like a corporation because it's a quasi-collective entity, a legal fiction. So please do not molest and do not, upset the people basically incorporating and giving life to the voice of the state while they are doing so.
so I might jump on the Governor General question first, and then I just want to pull a few other things out from your answer, Dimi. But to give the context, the reason Tamsin asked this, and I suggested it, actually comes from another of our co-hosts, Dina Savala, who, when she was teaching immunities, when she was a colleague of mine at Australian National University, she's now at University of New South Wales, but she was teaching our public international law undergraduate course. And we teach a week on immunities. And one of the students asked her, would the Governor General of Australia be immune? And she brought it up with me because she thought it was an interesting question. And I said, I have no idea. My inclination is not, but I don't really know. And so I've been throwing it around a bit in my head. Now, the reason why the Governor General might be immune is because we're often told as a shorthand that they're either the head of state of Australia or a representative of the head of state of Australia. Actually, it's a little bit more tricky than that. As I discovered, I went down this wormhole of constitutional law and the development of the position of the Governor General. I'm still not really there. But when the Governor General position was first established, they certainly were a representation of the monarch, and they were very considered close to the monarch in terms of being their personal representative, with dual imperial and domestic constitutional functions, both an agent of the imperial government and a personal representative of the monarch. And so at that point in time, and this is back in sort of the early 1900s, 1910, 1920, at that point in time, the divine right of kings model of head of state immunity was still very much in play. And so perhaps at that point, the Governor General would have been considered to be cloaked a bit with that head of state immunity of the monarch. But things have progressed a lot since then, both in understandings of immunity. I mean, just as a side note, when I was doing some historical reading for this, it was suggested in some of the historical texts that the American president wouldn't have the same degree as immunity as the British monarch because they were just a president and not a monarch. And so they didn't have that divine appointment which gave them immunity. So we've moved away from that thinking. We no longer think of immunity as God-given. We think of it as to do the function of the state, as Dimi was saying. And so I think the answer now is, does the Governor General possess those functions of the state in their acts? And, sort of taking the case of the International Court of Justice, the arrest warrants case that the Democratic Republic of the Congo brought against Belgium, in the separate opinion of Judges Kooijmans and Bergenthal and Higgins, those judges went through sort of the factors as to why a foreign affairs minister has immunity. And that's considered a way of looking at positions which are not one of those troika, not the head of state or head of government or foreign affairs minister, and asking, would they also carry immunity? Do they represent the state in this certain way that means that they have to carry out these functions without being interfered with? And I think with the Governor-General, that is arguable. A lot of the things that the Governor-General used to do in terms of being consulted before Australia went to war, for example, doesn't happen anymore. Their role has become very much more ceremonial than actually representing the state in matters. So I think at the end of the day, the argument I think would be difficult perhaps to support that they would have immunity. However, it's a very international law answer, because my conclusion is it probably actually doesn't matter, because they're designated as an internationally protected person under a separate UN convention, which doesn't give them individual immunity per se, but it does give them a framework that they're treated differently than just a regular civilian going about their job. So my answer to that is still, I don't know, but it is an interesting question. The other thing I wanted to bring out, just in terms of looking at functional immunity, when we're talking about jurisdictional immunities of the state, one of the things we said was, well, Germany committed war crimes. War crimes are clearly illegal at international law. They're one of the considered worst category of crimes at international law. Yet it was still accepted by everyone that they were official acts of the state of Germany. Their illegality didn't transform them into non-official acts. But when we look at personal immunity ratione materiae, there is a growing suggestion that certain illegal acts should not be considered as capable as being official acts, even if they were in fact conducted, wholly with the state's blessing and consent. And really, this started with the Pinochet decision of the House of Lords, where the House of Lords considered or suggested that torture shouldn't be considered an official act of the state, such that immunity ratione materiae would attach to it. And it is now developed into the draft Article 7 of the ILC's articles on the immunity of state officials from foreign criminal jurisdiction. And draft Article 7 has not been adopted. It is contentious. There is disagreement about it. But it sets out a list of international crimes which are considered to be so serious such that immunity ratione materiae shouldn't apply to them. Personal immunity still would. So while the person's in office, they would be immune. But once they leave office, they would not be able to claim official or functional immunity for these crimes. So I find it really interesting because it's a different approach that's being taken on one level to the state, which says it doesn't matter how bad the crime is, it's an official act of the state and it attracts immunity. And the person, where there is this developing area saying there are some things that are bad enough that we will not attach functional immunity to them.
Okay, so I have a follow-up question here that relates to, that is not on the thing. How do we then square this with the ICC decision? I can't remember. I think it was al-Bashir saying that the ICC isn't bound by these immunities when they have jurisdiction.
Okay, this is a great question. So just a few thoughts there, because I always use this, let's say, dipole between the ICC and the British courts in Pinochet to explain to my students how immunity operates. Immunity is not just sovereign equality. It is premised on two fundamental notions. As James Crawford suggested, first, the international dispute settlement rule, basically that certain cases should be adjudicated by the international authority before a properly constituted international court. And on the other hand, the principle of domestic jurisdiction. Some issues are so sensitive and so closely connected to the idea of sovereignty that cannot be adjudicated by another sovereign state's courts and, generally speaking, judicial authorities. So before the ICC, premised on the idea that international courts do not engage with state immunity or with the immunity of high-ranking officials, either incumbent or former. Immunity cannot be invoked. This is something that has been codified and accepted by sovereign states ever since the London Charter for the Constitution of the International Military Tribunal in the Nuremberg. So this is something that, whether we like it or not, because I know that there are a lot of dissenters, both in theory and in practice of international law, international criminal law, this is something that has been accepted for a fairly long time. And it makes sense, because some crimes are so grievous, they are so grave, they are so important that they need to be adjudicated at the international level by a properly constituted international court. To fight impunity, to exercise justice in a universal way, to apply public international law, international criminal law directly and not without the mediation of domestic statutes that may complicate things. There are a lot of reasons, but these are pre-legal or extra-legal. Legally speaking, before the ICC, before another international criminal court of some sort, either an ad hoc tribunal or even, I don't know, a hybrid tribunal, immunity is not engaged. And allow me to point out that the engagement and or activation of immunity is a reoccurring theme because, for example, freezing Russian assets to secure reparation for Ukraine through executive or legislative acts supposedly does not trigger immunity. The same thing happens a fortiori in the case of an international criminal court or international criminal judicial forum exercising jurisdiction over a person indicted for serious violations of international law like war crimes, crimes against humanity, or genocide, as in the case of al-Bashir.
Okay, so what I'm hearing is that if you're a head of state who wants to, not be affected by the fact that the ICC is not bound by immunity, you shouldn't go commit crimes in territories where the ICC has jurisdiction, if your state isn't a party. That's what I'm hearing, is that that's the argument
Yeah.
for protect yourself is don't do the war crimes and genocide.
Mhm.
Um,
I think you can just
where
stop there. Just
Yeah,
don't do the war
I'm
crimes and
like the
genocide.
genocide. Yeah,
Yeah.
look,
Yeah.
I'm actually cool with that as a slogan and motto for an international leader is don't do war crimes and genocide. But if these leaders are insisting on doing them, they need to do them somewhere that the ICC doesn't have a territorial jurisdiction in some way or another due to ratification of the Rome Statute.
Yeah, and I think that's really important because this is where some of the controversy occurs, right? Because there are existing arrest warrants for Putin, there's an existing arrest warrant for Netanyahu. Now, the ICC statute, when countries ratify it, one argument is, well, they effectively agree to the waiving of immunity for their leaders. But as you've said, Tamsin, the ICC also covers areas where crimes are committed. If they're under ICC jurisdiction, even if the person committing those crimes, their country hasn't ratified, nonetheless, that person's immunity is also considered not to apply before the ICC.
And I mean, I remember this blowing up when the former prosecutor pushed forward with investigations into war crimes committed in Afghanistan under a
Mm,
territorial thing, and the US
mm,
flipped the fucking table because, they commit a lot of war crimes. I can't tell you which ones, I don't have the evidence before me, but just statistically, they probably committed a fair few war crimes in Afghanistan, and they have a very big position about not having their troops before The Hague. I'm pretty certain they still
mm.
have the Hague Invasion Act active in their legislative books, but prima facie, they would have jurisdiction over US personnel because of the location, the territorial jurisdictional principle that the court gains over Rome Statute ratification, yes?
Yes, absolutely.
Yeah.
Yeah.
Okay,
Which,
please
we,
carry
we,
on.
I was about to say, which is why I was about to say the USS loves the ICC. That's not true. The USS never loved the ICC, but the USS under previous presidents has liked the ICC more at different times, but it never likes the ICC when it suggests it's investigating Afghanistan. And it
Yeah.
doesn't matter who the president is.
No, no, because how dare you investigate the US and the US shitfuckery, which is the technical term. Um, all right, so let's move on. So we've spoken a lot about the different types of immunities. So how do all of these immunities relate to attribution and state responsibility?
So, attribution and state responsibility are concerned first and foremost with the conduct itself. Attribution asks a very precise legal question: when can a particular act or omission be treated in legal terms as an act of the state? This this is already an important threshold because states only act through organs, officials, agents, armed forces, and all the different instrumentalities they might possess. So one must first decide whether the conduct of some kind of officer, minister, or any other civil servant, an actor acting on behalf of the state, is legally imputable to the state itself. Once the step is taken, the law of state responsibility asks the next big question: if this conduct is attributable to that state, and if it is contrary to an international rule or obligation, what follows from that? Immunity, on the other hand, answers a slightly different legal question. It does not primarily ask whether the conduct is wrongful, nor does it ask in the first instance whether responsibility exists in the abstract. It asks whether a particular court in a particular state may adjudicate the matter at all. So, analytically speaking, attribution and state responsibility belongs to the law governing conduct and its consequences, where immunity belongs to the law governing the exercise of jurisdiction. One is about the existence of a wrong and the legal consequences that follow suit. The other is about permissibility of judicial intervention within the framework of a given forum. That is why I think it is useful to connect immunity with the broader edifice of international dispute settlement. Immunity is not merely a technical shield or a residual courtesy between sovereigns. It also reflects a structural choice within international law about whether certain disputes are to be handled and where they should be heard. One way of putting the point is that the rule of immunity can be understood as the counterpart of two basic features of the international legal order: the adjudication of the international level, as we discussed, which generally depends upon state consent, and the idea that certain matters remain within the sphere of a state's own sovereign authority and jurisdiction. So the relationship between attribution, state responsibility on the one hand, and jurisdiction slash immunity on the other hand is not one of contradiction, but fairly speaking, one of allocation. Attribution and responsibility identify a sovereign wrong. Immunity may then kick in and determine that the wrong cannot be judicially pursued in this or that municipal forum and judicial authority. The claim is not extinguished, of course, in some metaphysical or even some legal sense, and I point that out because sometimes people tend to, let's say, merge immunity into prescription or other, let's say, legal institutions that nullify or impede the exercise of rights and claims. Rather, the law relocate a case, relocate a dispute to another juridical plane, the interstate plane, where the relevant vocabulary is no longer that of private litigation before a domestic court, but, for example, diplomatic protection, negotiations, maybe countermeasures, interstate proceedings, or some other form of peaceful settlement. In that sense, immunity does not necessarily erase responsibility, but it may instead redirect the way responsibility is to be pursued. And here again, I should point out that we should not be all too benevolent about the idea of solving a case at the international arena premised on the principles of law, justice, equality, and whatever, because most of the time, states are not under a legal obligation to solve all their disputes, only the disputes that threaten the international peace and security and stability of the world. And they are bound to follow, the Pacific settlement of disputes toolkit provided by the UN Charter and customary international law. But what it is not always, pointed out is that this toolkit comes with material constraints that are not necessarily mediated by international law. For example, imagine the case between Namibia and Germany, where Germany offered an official apology for the first colonial genocide of the 20th century. Germany pointed out that it is a genocide from today's perspective concerning the hetero and normal populations, but from today's perspective meant that it is not legally speaking a genocide, so whatever I'm offering you as a reparation is not necessarily given to make amends. It is not offered to, officially apologize and assume responsibility for an atrocity which, even at the time of its perpetration, was unlawful under the applicable rules of international law. But I'm offering it, out of the magnanimity and, the generosity of my heart, which is really important because Germany would pay victims in both Italy and Greece, but only ex gratia, not as an assumption of legal responsibility. And this is something we need to keep in mind. It's not about paying money to victims. It's about the underlying legal cause and the political, ideological, and historical connotations of this, cause.
One thing, and this is perhaps a more technical point that I just wanted to pull out a little bit more, is that relationship between state responsibility and attribution in particular and immunity ratione materia, or official functional immunity. And the reason I bring this up, I have to say, if you ever want to stress test an idea, try and put it in a problem exam that 500 undergraduate law students will look at. Because there is nothing to bring out things you didn't even think of than 500 very motivated, very bright students pulling your problem to shreds. And every year I mark these exams and I think, oh, I didn't think of that, but it's a good point. And one of the ones I got into a hole was I wrote this really lovely, well, I thought it was really lovely exam question about a official who broke into a secure facility using her official pass to get in there, stole a satellite, attempted to launch it. The satellite crashed, it caught fire, some people were killed. And there was a question both of attribution of her acts to the state, but also of her own personal immunity, her own official immunity. And a lot of students argued very confidently that because her acts would be attributed to the state using Article 7 of the Articles of State Responsibility, that they would also be official acts for the purposes of official immunity, of functional immunity. And although I can see the logic in that argument, as far as I know, there's nothing necessarily equating those two lines of law that neatly. So they're the same concept, but they've sort of developed in parallel. And so on the one hand, you have a string of cases about what is an ultra vires act that will nonetheless be attributable to a state. And on the other hand, you have the question of what are ultra vires acts that nonetheless attract official immunity. And I just find it interesting that the students saw that link very instinctively, but international law, to my knowledge, and I may well be wrong here, but to my knowledge, I don't think there's a case that has considered the two together and said that, yes, if it is attributable to the state, it also attracts immunity.
Yeah, that's fascinating. I can see the logic, but yeah, I also go with the fact that that doesn't necessarily hold because it may be attributable to the state but because it's ultra vires, it doesn't necessarily attract the immunity because, yeah, this is a whole tangent that I am not going to go down right now, but we can discuss this one over coffee sometime, Imogen, because there's a whole lot going on there, and we may have a paper to write. But moving on, Dimi, you've recently written a book on Greek perspectives to immunities, and we're going to put a link to the book in the show notes. It's an excellent book. How does this Greek perspective to immunities diverge from the general international law approaches we've been discussing in this episode so far?
Thank you for the question, Tamsin. So the book really grew out of a sense that the Greek perspective or the Greek approaches had been treated, if it was noticed at all, to be honest, as something peripheral or illustrative, whereas I came to think that it actually offers a very revealing lens through which to understand the development of law. and more broadly the development of the underlying structure of the regime, the underlying architecture of the regime of sovereign immunity. What I try to show in that book is that the Greek approach diverges from the standard international law account in at least two important respects. The first is that the Greek experience is not particularly well captured by the familiar linear story we tend to tell about immunity, that the law moved rather neatly from absolute immunity to an era of civilization and, enlightenment, which brought restrictive immunity and then perhaps a more procedural understanding of immunity, especially after the issuing of the judgment of the ICJ in the jurisdictional immunities case. So the Greek trajectory is much less linear. Quite honestly, it's a hot mess, but it's also much more dialectical. So Greek practice oscillates over a long period between two postures of sovereignty. On the one hand, there is what I call souveraineté sage, the wise sovereignty, a more prudent and accommodating posture, where Greece accepts functional and procedural limits on sovereign immunity in order to secure legitimacy, diplomatic support, financial credit, or simply a workable place within a wider system of power at the international level. All these things are not legal, by the way, but are closely connected to the idea of asserting immunity or exercising jurisdiction. And on the other hand, there is the sauvage sovereignty, the wild sovereignty, souveraineté sauvage, a more assertive posture where Greek actors invoke fundamental rights, self-determination, higher moral principles like dignity and humanity, or the protection of the state's own reserved sphere in order to either claim immunity very strongly or resist the exercise of jurisdiction just as strongly. So the Greek story is one of, let's say, recurrent movement between accommodation and assertion. And the second point is that Greece did not simply receive the law of state immunity from elsewhere. Sometimes we tend to think that the smaller states copy-pasted solutions from more powerful actors. Almost every handbook that addresses the issue of sovereign immunity has a specific chapter about the Schooner Exchange versus McFadden from the United States, and quite possibly the Christina or other cases from the United Kingdom courts, but it has little to nothing to add, for example, for pioneers on the restrictive doctrine of sovereign immunity, like, for example, Italy, Belgium, and to a certain extent, Greece. I think that is often overlooked because obviously Greece is not usually treated as one of the canonical producers of international legal doctrine. However, once one looks carefully at the practice, the exchanges, the judicial and doctrinal material, that becomes much harder to sustain. So the Greek perspective is not just illustrative. In some respects, it was constitutive. And just for the sake of brevity, I need to, let's say, address a few examples to substantiate that and basically to plug in a few, let's say, sneak previews from the book, just for commercial purposes, I guess. So a very good example is the Zapas affair between Greece and Romania at the turn of the 19th century. So basically, Greece and Romania claimed before Romanian courts the inheritance of two insanely rich people who were all Greeks, but also Wallachs, so they might have some kind of Romanian affiliation, and they were very, very wealthy. We have a whole, let's say, palace in Greece called the Zapion from this guy, from the two Zapas cousins, and also they were the financing incentive behind Greece's reinvigorating the vision of the Olympic Games. Zappa's money brought the Olympic Games back into life. So, in the Zappos affair, Greece used immunity and extraterritorial rights not just as a technical jurisdictional argument, but as a way of negotiating hierarchy within the post-Ottoman order. Ever since the 1830 and the establishment of the Greek state under the London Protocols, Greece basically says for over the course of the long 19th century that we have to claim this super immunity based on capitulatory rights because we are a European, civilized, Christian polity, and all the other bits and pieces coming out of the Ottoman Empire, you are subjected to the law of capitulations. You are legally inferior. So This is really interesting. This happened in the Zappos affair. The same thing happened to a certain extent when Greece was subjected to international financial control during the after 1897. Again, Greece used sovereign immunity to fence off the attempts of German and Austrian creditors to impose financial control. Obviously, it was not very fruitful. The same thing happened, obviously, with during the Second World War, with Greece's, engagement with the mixed courts of Egypt, because Greek forces were deployed in Egypt to fight alongside Britain and Australian forces against the Axis powers. And obviously, Greek servicemen like to drink a lot and brawl a lot and violate orders and go to bars and clubs. And they sometimes, very often, to be honest, committed crimes while on service, en service commandé, as the legal term was, and through the engagement of the mixed courts of Egypt with Greek claims and the claims of Greek servicemen, something really concrete emerged within the field of international law and sovereign immunity. The distinction between acta iure imperii and acta iure gestionis is especially focused on the territorial tort exception, which is something that was basically litigated before the ICJ in the jurisdictional immunities case. And also, we have referred to the international aspect of this case, but the Greek aspect of this case has to do with the claims of thousands of Distomo citizens from the martyric village of Distomo, who claimed reparation before German courts, Greek courts, Italian courts. At some point, they achieved, under very precarious legal reasoning, to be honest, to achieve justice nominally before the Greek courts. However, while the case was pending before the International Court of Justice, a very extraordinary and powerful Greek court, the Supreme Special Court, which is not, the Supreme Court in the common law sense, it is a court that can solve jurisdictional conflicts between and legal issues between the various courts and tribunals of Greece, decided that, no, Germany was right. We do not have the power to lift sovereign immunity or disregard sovereign immunity. And the idea here, and this was something that my late mentor Antonio Augusto Cansado Trindade really pointed out during the hearing, was really, stunning. Greece intervened to the case. Greece supposedly, provided arguments to defend the Italian position, but at the same time, in foro domestico, the Greek courts were in agreement with German interpretation of legal arguments. So, yeah, to summarize, basically, the Greek perspective is not just a local color, giving just some ideas about how Greece applied the law of sovereign immunity, but it epitomizes how a semi-peripheral state has repeatedly negotiated hierarchy, foreign pressure, intervention, dignity, sovereignty, and agency, and basically showcases that international law is a normative vocabulary that states utilize to basically make arguments and support themselves all through this period of imbalance which we are still experiencing.
That's a really fantastic snapshot of the excellent work you've done in this book, and I'm sure our listeners will definitely be going out to get it, grab a copy and have a read after hearing that. We are going to move to wrap up because we've been speaking for a little while now. And in wrapping up, we usually ask a non-international law question about escape routes, what people are reading, what are listening to, or doing to take your mind off international law. But in season 3, I've still been given a free hand on this question. No one has enforced a question on me yet. And so as a former chef, I'm asking all about food. What is your ultimate comfort food? Where can you get the best version of it? And where can our listeners get a solid recipe to make it at home?
Okay, this is a very good question, and I'm very relieved that the end is about food rather than, law or immunities or whatever. So my ultimate comfort food is bagina. It is an unpretentious pie from Thessaly, my home region, where this is something that has to do with why I like it so much. It is the kind of food that does not try to impress anyone, to be honest, but ends up doing so anyway. So it is made with grated courgettes, flour, a little olive oil, and usually feta, although one can make a very good vegan version with tofu or with some plant-based cheese. It comes out somewhere between a pie and a baked savory pudding, soft in the middle, slightly crisp at the edges, deeply summery, and wonderfully reassuring. As for where our listeners can find a good recipe at home, I would happily point them to a Greek chef, Akis Petragikis, who is the only chef that has also an English version in his site and offering this recipe because it is reliable, clear, and very close to the spirit of the dish. However, if you want to really try something that would blow your mind, a version of vagina that would be wonderful, find a village with an oven built outside in central Greece and ask a good old granny to give you vagina. She will give you vagina and it will be the best vagina you have ever tried.
And I've got the link to that recipe, so we'll include that link in the show notes as well. Imogen?
That, yeah, that sounds so delicious, Demi. I want some pacina now. Like you, Tamsin, I am also a big foodie, and so asking me to pick my favorite any type of food is like asking me to pick my favorite child. I can't do it. And my answer is
But
probably
you
going
do
to
have
be,
one.
of course, everyone has a favorite child. We just don't tell them.
Exactly.
I don't have a favorite child.
Of
Um,
course you don't.
and and so my favorite food is often what I ate and enjoyed last. But for comfort food, one thing I've been really enjoying at the moment is ramen. And there is in particular a Recipe Tin Eats version of ramen. It's called a quick ramen. It takes about an hour. It's pork based, and you make a really rich, fatty pork mince stock that you then take the pork mince out and crisp that up with some sugar and soy sauce to go back in at the end, as well as fresh corn and a pat of butter. And that sort of unctuousness and sweetness and savoriness and saltiness, it's just delicious. And everyone in my house loves it. I highly recommend it. It's in one of Nagi's cookbooks. I forget which one, but we can link to it in the show notes.
Fantastic. That sounds delicious, and I want all of this right now, but instead, I'm gonna go make a chorizo penne with a Napoli sauce for dinner instead of that. So, we'll make do with what's available. But that is all we have time for in this episode. Thank you so much for joining us, and listeners, we will talk to you next time. Bye bye.
Bye.
Bye.